Hello.
Hello, can you hear me?
Yes.
Very good. How are things in Paris?
Good.
Excellent. I'm still in the Dordogne in the more central south part of France, so nice here as well.
Mm-hmm.
Hi, everyone.
Hello.
Let me just switch my background to something more.
How do you find additional backgrounds? I couldn't. Or do you have to upload photos?
I
Can you
downloaded them.
your logo if you want?
Are you muted? No. You can see, right, whenever
Yeah.
someone talks, it's muted themselves.
Hi, everyone. Are you hearing me?
Yes.
Yeah.
Yeah, hi. Janice is muted for the time being.
Hi,
Evelina, hi, Victor, hi, Steve.
Hi, Hwang.
Yep.
Hi, everyone.
Hi.
So, at exactly 4 p.m. Singapore time, 3 p.m. Bangkok time, I will open the webinar.
So we are not visible. I mean, we're not visible or audible to the audience at the moment, right?
Benyapa?
คุณเบญญาภาคะ
ฮัลโหลค่ะ
ตอนนี้ audience ไม่ได้เห็นเราใช่ไหมคะ
ตอนนี้เห็นเหมือนกันค่ะ แต่ตอนนี้ audience ยังมีประมาณ4 ท่านค่ะ
เขาไม่ได้เห็นเราใช่ไหมคะ
เห็นค่ะ
อ๋อเขาเห็นเราแล้วเหรอคะ
ใช่ค่ะ ตอนนี้สแตนบายแล้วค่ะ
Oh, they are visible to the audience.
Right, we're not visible yet.
We are.
We
เอ้ยนี่เปิดให้ audience เห็นเราแล้วเหรอคะ
Attached to this slide. This is
แป๊บนึงนะคะ
paragraph 1 of the series.
Yeah. I did some notes. Just in case I've already silenced it. Okay. Just in case it buzzes, we can just switch it on.
Sequence of events.
I think I'm number 2. I think she starts.
Okay.
Then I think it's not. I think there's an email somewhere.
where's the model documents? You got to produce your. No, I want Article 32. Model law itself it doesn't look like model law. This doesn't have some print. For A. Give me the page where there's judgment, announced judgment. I have not got the whole document. I have one which is just the selected pages. This is the example. The Java judgment. Control.
I don't feel it.
Notes here. There's a note from somebody. That's one that you can note something that gives me the number of pages of the procedural history.
Something to me at the start.
Can you look this?
Yeah. 85 pages of procedural history.
That's right.
You want to read it in software.
Okay, hello everyone. It is now 3 o'clock in Bangkok time, and welcome everyone to the series 4 of the THAC webinar series. For today, today's webinar is regarding due process paranoia, dilatory tactics, and their impact on international arbitration efficiency. So we're very, very much privileged to have with us all of our speakers here today, who are all incredibly esteemed practitioners and arbitrators in their own right. And we'd like to thank everybody for taking the time to tune in with us today during our webinar. So we will be having our webinar today from 3 p.m. to 5 p.m. Bangkok time. Today's topic is really quite interesting, and I think we're, as I mentioned, quite lucky to have really good and very, very experienced practitioners and arbitrators with us. As we all know, due process paranoia, which is the subject of today's discussion, is generally defined as a reluctance by tribunals to sanction a party in certain situations, particularly where they fail to comply with the arbitral procedure, due perhaps to an apprehension that the resulting award could be challenged on the basis that the party did not have an opportunity to fully present its case. This can manifest in situations where, for example, a party applies for multiple extensions of time, makes several amendments to its submissions, or introduces new evidence or legal theories very late in the day. And oftentimes, the tribunal's indulgence of the procedurally non-compliant party can be very frustrating to the other party, particularly if the other party is generally procedurally compliant or reasonable. Effectively, the compliant party can end up bearing the consequences of the non-compliant party's disregard of the procedure. For example, they may have to respond to very late evidence or legal theories on a very shortened timeline. And for these reasons, and perhaps other reasons, which we will discuss today, in the 2018 Queen Mary survey, respondents have found that the lack of effective sanctions during the arbitral process was one of the biggest shortcomings in arbitration. In today's webinar, we will do a deeper dive into this subject and discuss, among other things, what are the potential due process concerns, whether this paranoia is actually warranted, in other words, whether there is a real threat to the resulting award in certain jurisdictions, whether there should be an expansion of the tribunal's power to issue sanctions, perhaps, or if the current powers that tribunals have are actually sufficient and just need to be better executed. And generally, how efficiency and fairness can be improved. So, as I mentioned earlier, we're very privileged to have with us a very good lineup of speakers. And I'll introduce all of them very briefly in turn. Of course, most of them are quite well known, and if you do need to look further into their profiles, please feel free to look into the THAC website. First, we have Vanina. She specializes in international arbitration and has experience advising local and international clients on a diverse range of cross-border disputes involving commercial contracts, investigations and anti-corruption, joint ventures, insurance and reinsurance, construction and infrastructure projects, environmental contamination, and investment treaty arbitration in San Francisco, Paris, Bangkok, and Hong Kong. Hi, Vanina. Second, we have Dr. Michael Huang Sc, and he is, of course, another well-known arbitrator. He currently practices as an international arbitrator and mediator based in Singapore. He was the Chief Justice of the Dubai International Financial Center, or the DIFC courts, from 2010 to 2018. And he sits as an arbitrator in domestic and international disputes, including investment treaty disputes, under a wide variety of arbitral rules. Thank you very much for joining us today, Dr. Hwang. We also have Victor Leginsky. He is a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators. He is certified as a mediator through the Center for Effective Dispute Resolution in London and works frequently in respective mediation with the Royal Institution of Chartered Surveyors in London and the Chartered Institute of Arbitrators. Hi, Victor. How are you today? And then, of course, we have Professor Steve Moore. Professor Steve is an arbitrator, academic, and arbitration specialist. He is the founding president of the Beihai Asia International Arbitration Center in Singapore, established by the Beihai Arbitration Commission, Guangxi, in furtherance of the China-ASEAN trade links and dispute resolution. He is also a chief advisor of the newly established Myanmar International Arbitration Center, a member of the Asia Advisory Board of the American Arbitration Association, International Center for Dispute Resolution, or the AAA ICDR, a council member of the Hong Kong International Mediation Center, and a member of the Ethics Council of the Association of Indonesian Advocates. Hi, Prof. Steve. So we will begin today with short presentations from each of our esteemed speakers. And after all the presentations are done, we will have a free-flowing discussion. So at any time that any of you have any questions for our speakers, or questions about the topic in general, which of course is a very, very meaty topic, please feel free to submit it via the Q&A button in your Zoom app. And we will tackle all of these to the best of our abilities within the time provided to us after the presentations of the speakers. So we will start with the first presentation by Vanina. So Vanina, I'll turn over the floor to you.
Thank you for the kind introduction, Janice. Sawadee ka. Good afternoon, ladies and gentlemen, and good morning to some of you who are not in Thailand. May I have the first slide, please? We all know commercial battles are not fought in a calm pond. And there are plenty of tactics that counsel can and should engage in order to protect their client. But some counsels take this too far when they employ dilatory tactics, or as many people in the international arbitration community refer to as guerrilla tactics. They delay, disrupt, and sabotage arbitration proceedings, ranging from acts that are unethical to those that are downright criminal. Willfully delaying and obstructing proceedings cause guerrilla tactics synonymous with dilatory tactics. So what I will cover today is what are guerrilla tactics, the categories of guerrilla tactics, some common examples, the impact on Thailand, as well as countering guerrilla tactics. Now let's move on to the next slide. What are guerrilla tactics? The previous slide, please. It has been said that international arbitration dwells in a no man's land. So you may wonder, where do we draw the line between a zealous advocate and an arbitration guerrilla? After all, in international arbitration, the differences in norm often stem from conflicting ethical rules, clashes between legal cultures, what the Brits consider unlawful rehearsal. Hold on, I believe I'm having some sound issues. Please excuse me while I just check on the sound 1 second. Is the sound any better?
Hi, Vanina. I think there's a bit of interference with your mic.
Let me see if I can use earphones. Apologies, everybody. We did do a test run and it was fine. So
I think it's better now on my end.
oh, is the sound okay? Okay, thank you. Thank you, Grace. Okay, thank you, Roland. Okay, so it has been said that international arbitration dwells in an ethical no man's land. So you may wonder, where do we draw the line between a zealous advocate and an international arbitration guerrilla? After all, in international arbitration, the differences in norms often come from conflicting ethical rules and clashes in legal cultures. What the Brits consider unlawful rehearsal of witnesses is common practice by the Americans. European councils and tribunals are often frustrated with the American lawyers' incessant objections and aggressive cross-examination. At the same time, Asian parties can find European counterparts inflexible when it comes to negotiation and mediation. But these are not the types of issues we're covering today. The central issue here is when councils no longer use safeguards provided by arbitration law, such as the right to challenge arbitrators or the right to be heard as a shield, but as a sword to attack the integrity of the arbitral proceedings. Renowned arbitrator Michael Moser has defined guerrilla tactics as unusual, unconventional tactics designed to delay and obstruct proceedings. Gunther Horvath quite correctly remarked, guerrilla tactics range from completely illegal, inappropriate, such as witness intimidation and phone tapping, to the merely sly, such as ambushing the opposing party with new evidence or ex parte communication with arbitrators. While some guerrilla tactics are outright criminal, many of them do not necessarily amount to a violation of the law or written procedural rules. What we can deduce from this is that there are a range of such tactics as counsel's arsenal, for the sole purpose of which is usually to undermine the efficacy of arbitral process. Generally speaking, it is usually the party with the weaker case that employs such tactics to delay the legal battle and wear down the other party. So elusive the term guerrilla tactics that one might need to resort to the famous obscenity standard enunciated by the US Supreme Court. I know it when I see it. Now let's discuss the categories. A potential method of categorizing guerrilla tactics is to consider the nature and gravity of the conduct, which results in three broad categories. It is important to distinguish between subtle misconduct, the so-called rough riding, and actual guerrilla tactics. Rough riding resides at before a type of ethical borderline, whereas guerrilla tactics most definitely cross border. A third category of extreme guerrilla or guerrilla Talibans also exists, which involves abuse of state apparatus or the commission of illegal acts. Now let's further look into these issues. So just to talk about some common example, the so-called rough riding is technically legal. Often, however, rough riding violates the very spirit of international arbitration, basic rules of professional courtesy, or even fair play. Rough riding includes withholding of evidence, last-minute surprises, such as introducing new arguments on the eve of the hearing, or introducing new evidence through witnesses. It also includes a refusal to cooperate. A party may refuse to comply with the Secretariat's direction or request. Another form of rough riding is a deliberate disregard of professional courtesy. For example, a counsel may exploit opposing counsel's personal availability, withhold consent on small procedural issues, or even reject an opposing counsel's request for a 24-hour extension to attend a funeral. Be deliberately unavailable, launch excessive documents requests, attack nervous witnesses, challenge an award using expansive grounds like public policy. I remember from a case that a counsel basically stated that various witnesses were unavailable for months and months, furthering delay the case. In case you're wondering, that case took over 10 years, and it is not the only case in Thailand that took over 10 years during the course of my practice. Now, the most common practice, next, we come to what are typically known as the most common form of guerrilla tactics, those that are both regularly invoked in international arbitration and amount to obvious misconduct. I will give just some examples that are particularly relevant to Thailand. In Thailand, it is seeking anti-arbitration injunction, and this may also be relevant to other jurisdictions as well. And I wait for my esteemed colleagues to weigh in about whether or not these tactics are currently deployed. Hold on one second. In Thailand, it is very common for parties to completely ignore the arbitration agreement and rush to the court and get an anti-arbitration injunction. During my time as counsel in Thailand, and even recently, I have observed that counsels often challenge the very existence of the arbitration agreement and often suggest that the parties have never agreed to arbitrate, despite there being an arbitration agreement. This is nothing but a delayed tactics, since the Thai courts would generally uphold the arbitration clause, but the entire process could take months. Procedural delay tactics. Delay tactics amount to one of the most common guerrilla tactics used to complicate and derail the arbitration. The most egregious form would be the refusal to participate altogether, while less serious delays include late filings of submissions, reports, exhibits, and last-minute cancellation of hearings. Other tactics include refusing to sign the terms of reference, continuously and abusively requesting extensions of time, persistently refusing to file submissions on time, failure to comply with tribunal's order, failure to pay deposits, leaving the other party to make these payments on their behalf, making inappropriate objections mounting to a series of unmeritorious applications, and upon rejection by the tribunal, then challenging the arbitrators for being biased, appointing, dismissing, and replacing counsel at the last minute, which means the new counsel would require additional time to familiarize with the case. Now, this is one of the very common one in Thailand, which is challenging the arbitrator on frivolous grounds. Challenges of arbitrators are on the rise as dilatory maneuvers, not just in Thailand, but also with other arbitral institutions. They are particularly disruptive when filed late in the proceedings. While the right to challenge an arbitrator is fundamental and indispensable right of all parties, challenges are often used solely to derail proceedings or reverse undesirable decisions. I was once on a case where it took 10 years to constitute the tribunal due to the incessant challenges based on various frivolous grounds such as political affiliations. Now, this case was a commercial case. It was not a case involving the government. But some of you may recall about the red shirt, yellow shirt protest. And each arbitrator was accused of being either a red shirt or a yellow shirt. And sometimes in certain cultures, as soon as an arbitrator is challenged, he feels obligated to withdraw. So this caused a series of delays of years and years that led to finally, we got our tribunal 10 years later. And we had another arbitrator in another case who was an insurance silk, and the arbitration agreement requires somebody with 10 years of experience in insurance. Our arbitrator was challenged for years on frivolous grounds, such as the arbitrator does not speak the local language, does not know local law, because his law firm represents Japanese clients, therefore he's biased in favor of the Japanese. He didn't work in an insurance company, therefore he doesn't actually have insurance experience. So the story goes, and that also went on for several years. Some parties would also challenge the entire tribunal in hopes that this would provoke them to react and make some misstep on the party for later grounds to challenge the award. Extreme, and another, which is, it's not yet a trend in Thailand, but there is a provision where one can civilly sue an arbitrator if he has caused damage to the party. Now, generally, challenges to awards are always used as a matter of course on the ground of public policy, which is very widely interpreted. But this is just because the courts will take 10 years when you go to the Supreme Court to enforce an award. But I have heard of at least one instance of an arbitrator being sued. Now, I'm not saying that this is a common ground such as challenging arbitrators by any means, but it has now happened. Extreme guerrillas or guerrilla Taliban. The final category of tactics is what some would call arbitration Talibans. These includes violence of severe criminal acts. Some infamous cases are where the Indonesian government organized the kidnapping of the Indonesian arbitrator at the Amsterdam airport and the co-arbitrator appointed by the host state, who was shot a few weeks after he sat at a hearing that was moved to Geneva. Some examples of extreme guerrillas include bribery, violence, threats of violence on arbitrators, opposing counsels, or witnesses, blatant abuse of state authorities. And in Thailand, I would say that calling immigration office to have immigration police raid hearings to check on work permits and immigration status would also constitute a form of extreme guerrilla. Can we have the next slide, please? This one, thank you. Now, the impact of these dilatory tactics or guerrilla tactics can have a severe impact on not just the tribunal, but I wanted to speak about the big picture, and as well as, since this webinar is organized by the THAC, but also on Thailand as a seat of arbitration. I know this is a little bit outside of the scope of our topic, but just wanted to touch on a very famous case that has made basically a renowned story around the world, and it has impacted Thailand severely. So it is useful to recount Neil Kaplan's story when he sat as an arbitrator to understand the nature of guerrilla tactics and its impact on the seat of arbitration. Many of you obviously know Neil as the father of Hong Kong arbitration. This story happened over 20 years ago, but even on GAR, it was brought up in a panel in 2016. When traveling to Thailand a couple of decades ago to sign an award as co-arbitrator in a dispute that had gone on for 10 years, Neil was arrested on landing at the Bangkok airport for not having a work permit to sign the award. One of the party's representative has complained to the authorities, but I later heard from his co-arbitrators that it was actually both parties that were employing this guerrilla tactic. And in Neil's word, he said, "They made my life very difficult for the tribunal." This particular saga actually inspired countless of guerrilla lawyers in Thailand to use the same tactic. And I think Michael Huang will have some comment on this for his arbitration cases involving Thailand. But this is something as a learning lesson that one bad guerrilla can start a very horrible trend that can cause fear from arbitrators using Thailand as a seat of arbitration. Can we move on to the next slide, please? When thinking about countering guerrilla tactics, I know that my esteemed colleagues will speak about the tribunal's perspective. So I want to share some of my thoughts on the institutional aspect, because the onus should not only be on the arbitrators to curb guerrilla tactics. The onus should also be on the institutions being more robust. And I know that, for example, the Thai Arbitration Institute used to be very slow when it comes to challenges of arbitrators, because it would have to be first the arbitrator has to decide on his own within a certain amount of time, and then the co-arbitrators would decide, and they actually have to come and meet in person at the TAI, and this process took a very long time. And now the rules are amended that it would go to an independent umpire to decide. The THAC has set up an arbitrator committee to decide on this. And now this is a great improvement, but I wonder if more can be done. For example, the SIAC requires a fee of 8,000 Sing dollars, the 2016, for challenging arbitrators. Now this comes roughly to 5,800 US, which will not be a lot for large major companies. It comes out to 180,000 baht. But if compared to the filing fee of 2,000 Singapore dollars or 45,000 baht, it could deter these frivolous challenges in circumstances where every single arbitrator is challenged for being a red shirt, a yellow shirt, this and that. And then the parties may think twice about whether or not to file a challenge in a case where 5 or 6 challenges have been launched. So this is something for the Thai institutions to think about. And then perhaps the thoughts about cost shifting, which is not in the arbitration rules, because the Thai Arbitration Act only mentions the arbitration cost to be provided in the arbitration award. But query as to whether or not the institution itself can provide for rules on cost shifting, similar to the ICC, where some of the factors that can be taken into account is how expeditious the case has been run. Another one is the duty on the counsel. Now, the ICC rules has a duty on the parties to act expeditiously, but the THAC and the TAI could consider, and good faith is part of the civil and commercial code. So why not make the duty of good faith as part of the institutional rule to conduct the arbitration in good faith and also efficiently and expeditiously? And thoughts about considering looking to the LCIA Council guideline as well. So these are some of my takeaway and thoughts for the Thai institutions in terms of looking at some of the other institutional rules where dilatory tactics are so rampant in Thailand. So I will leave it at that. And if anybody has any questions, I will welcome them later. Thank you very much. ขอบคุณค่ะ
Thanks very much, Vanina. Our next speaker would be Dr. Michael Huang, and I understand he will focus on two main cases, the Jaguar case from Singapore and the Libanaco cases. So, Dr. Huang, the floor is yours.
Thank you, Janice. Good day to everyone, both in Thailand and elsewhere. I am just going to deal with a couple of cases in which I was personally involved. But the reason for focusing on these two cases is in contrast to what Vanina has been talking about, which is the actual examples of guerrilla tactics. I'm trying to find some legal principles which may be generally applicable on an international basis that might guide tribunals to devise measures to control and hopefully prevent guerrilla tactics from being used. So can I have the first slide, please? While the slide is coming up, sorry. Okay. Right. So the first case I want to deal with is a relatively recent case of China Machine New Energy against Jaguar Energy, Guatemala. And this case went through the High Court in Singapore and then later to the Court of Appeal. In this case, I acted on a very rare occasion as counsel. And it was a very interesting case because for the first time in my experience, at least in Singapore, a party came to court and asked for an award to be set aside on the grounds, among other things, that guerrilla tactics had been used by my client. And on that basis, they wanted to set aside the award which had been given by an international tribunal, which is seated in Singapore. And I've summarized counsel for the plaintiff. Its arguments are set out under four heads, and the argument was presented by a very distinguished English Queen's Counsel. Now, he approached the problem and picking up on a theme that Vanina was talking about just now. So the first point that he argued was that parties to an arbitration bear an implied duty to arbitrate in good faith. And this duty forms part of the agreed arbitral procedure. Second, my client's usage of guerrilla tactics had breached the duty to arbitrate in good faith. Third, because the tribunal had failed to restrain the use of guerrilla tactics, this amounted to a breach of the arbitral procedure which had been agreed between the parties. And as a result of this breach, the plaintiffs had suffered prejudice owing to a breach of the agreed arbitral procedure, and therefore the award should be set aside. And for reference, this would be Article 34(2)(a)(4) of the model law, which sets out this as a specific ground for setting aside. The High Court Judge, Justice Kanan Ramesh, worked on the basis that a duty to arbitrate in good faith existed. And this cuts through a lot of arguments. But because of the way he approached the problem, I will not spend too much time on the good faith point, although it's a very interesting point, and I'm happy to discuss this later on when we have the open discussion. And according to the judge, there wasn't any clear authority, even in English law, that there was such a duty to arbitrate in good faith. But for purposes of hearing this particular argument, he was prepared to work on the assumption that a duty to arbitrate in good faith existed, because he was going to make a finding that it didn't really matter whether or not there was such a duty that existed in law. And the reason is basically, first of all, on the facts, he was unable to find that Jaguar had resorted to guerrilla tactics during the arbitration. Now, I can't go into the facts in detail because we just don't have the time. Can I have the next slide, please? Thank you. And the judgment is very interesting to read, and he goes through several academic commentaries. For example, Gary Bond's textbook, which does advocate that there is such a duty of good faith. But the key point that he relied on is point 2. None of the commentaries suggested that guerrilla tactics can justify setting aside an arbitration award on the grounds that they reflected bad faith. And because where does a breach of bad faith lead you to? So according to counsel for the plaintiffs, this would amount to a breach of the duty to arbitrate in good faith, which in turn constitutes a breach of the agreed arbitral procedure. Now, what the judge found was this: a breach of the agreed arbitral procedure did not, in his view, include guerrilla tactics as such. So he did not want to, he wasn't prepared to have this link between the duty in good faith, if it did exist, which he didn't actually find, and the breach of the agreed arbitral procedure. So he was prepared to look at guerrilla tactics in isolation from the duty of good faith. And when he did that, on the facts, he said the matters complained of by the plaintiff did not, in his view, amount to guerrilla tactics, because standing alone, guerrilla tactics were not a ground for setting aside an award. It was only if the guerrilla tactics became extreme, or what he called certain kinds of guerrilla tactics, then you might be able to set aside, and that was to invoke the ground of public policy. In other words, extreme guerrilla tactics could equate a breach of public policy because the result would shock the conscience, which is the commonly used test, at least in Singapore courts, of whether or not there is a breach of public policy. Or, of course, it would be easy if there was actual fraud or corruption, because under Singapore law, fraud or corruption is an independent ground for setting aside. But he wasn't really so keen on pushing the good faith analysis because, and I quote from his judgment, this would be to implicitly expand the categories of conduct on the basis of which an arbitral award may be set aside. And he said, I have doubts over whether this is consistent with the philosophy of the model law and the International Arbitration Act of Singapore. In other words, he wanted to keep the grounds for challenge of the arbitration award rather tight and not based on what he felt, I suppose, was a rather loose head of setting aside that there was a breach of the duty of good faith. Okay? But he also addressed the issue of whether or not, in fact, there had been guerrilla tactics employed. And on the facts, he found that they had not. Now, one of the issues that will come up in later discussion will be what defenses can a tribunal adopt when they see guerrilla tactics going on? Because our case, and I speak now as the counsel, I was not counsel in the arbitration, by the way. I was only counsel when the matter came to the High Court. So it was quite clear that the tribunal in this case had realized that the claimants were adopting a very aggressive policy of running the arbitration. And there were various instances where procedural decisions made by the tribunal were complained of by the plaintiffs, the claimants. And what the tribunal did in this case was to write an extremely long judgment, an extremely long award. Yes, I know. Where did I paste it? The actual award was over 600 pages long. To be exact, 615 pages award, of which 85 pages were devoted to the procedural history as an annex. So the tribunal knew what was coming. They were very experienced. And so they had gone into what I would call defensive arbitration. And in the procedural history, which is as long as some awards, they had set out all the decisions that they had made, highlighting those which were contentious and explaining exactly why they had made the decisions which they did. And this helped a lot. And so that is a possible defense that tribunals who can see trouble coming can insulate themselves. Obviously, they have to be accurate, but if they explain their thinking in the context of the situation that existed at the time that the decisions were made, this would go a long way towards persuading a court which was reviewing the award of understanding the factors that affected the tribunal's decision. And so long as the tribunal itself acted in good faith, it would not be the public, it would not be the general policy of our courts to second guess the tribunal's decisions. The court might think that it would have come to a different decision itself, but they would certainly respect any conscientious decision made by the tribunal. So let me now move on and go on to the next stage. Next slide, please. Now, this case went to the Court of Appeal, which is of perhaps less importance in the current discussion, because when it got to the Court of Appeal, my opponent dropped the ground of guerrilla tactics by itself. Instead, he just focused on one aspect of the case, which he said violated another ground, which was the general ground that his client had been unable to fully present their case because of the way in which my clients had been producing documents for the hearing at a rapid rate and in huge numbers in the 6 months leading to the actual hearing. So basically, this is the argument called the document dump argument. You are just dumping documents on us and not giving us a chance to cope with all the new documents coming in. We barely cope with the last lot, and then you give us another 200, 300 documents. And so that was the complaint, and they relied on a slightly different ground. And I only highlight that ground because the Court of Appeal has also given a new interpretation. It's actually not a new interpretation. It has been around for some time at the High Court level. But this is the first time that it made a broad policy statement about how it would construe the doctrine of breach of natural justice, which is what this is all about, when you're talking about alleged breaches of that duty. So what happened was that although the plaintiffs had been complaining to the tribunal that they were under pressure from my clients in the never-ending wave of documents that were new documents that were coming in at a very late stage in the case. Again, the procedural history, which had been recorded by the tribunal, stood us in good stead because the tribunal could, the court could see exactly what the tribunal's thinking was. But in particular, the court itself said this: look, there was a whole series of things happening that you say made it impossible for your clients to prepare their case adequately. But you did not, and if I may use sort of a loose colloquial phrase, you did not make Custer's last stand. You did not, when the last bunch of documents came, maybe a couple of weeks before the actual hearing, you didn't stand up and tell the tribunal, we can't go on. We now have to apply for an adjournment because we cannot cope with all of this. Instead, they went on with the case. And it was only after they lost the case that they raised this particular argument about the breach of natural justice. So the Court of Appeal said, if anyone wants to come and complain about breach of natural justice, you have to raise it at the time. And this is a new principle which has been emerged from our Court of Appeal. Again, it is actually now another sort of weapon, if you like, in the armory of the tribunal, if it's accused of not having given the parties an adequate chance of presenting their case. Next slide, please. Now, since we're going to be talking about guerrilla tactics this afternoon, I'm just showing you the principal textbook on the subject by two authors. It's an interesting textbook. And if you look somewhere in the early chapters of the book, you will find that they have a chapter called the Etymology of Guerrilla Tactics. And one of the things that they investigate is where this term came from. And they have found that the first person to use this term was actually me. And I coined it in 2003 and published an article in 2005. And since then, the term has taken on a life of its own. That's just for your interest. Now let's move on to the next slide. But this is an important book. Now, the other case I'm going to talk about is Libanenko against Turkey. Now, what we've just looked at is an example of how guerrilla tactics work on a theoretical basis in commercial arbitration. This is now an example of how guerrilla tactics work in treaty arbitration. Now, my involvement in this case was I was the chair of the ICSID tribunal, which heard this case. Again, I don't have time to go into the detailed facts, but the relevant, this is one of the few cases in treaty history where the preliminary decision that was made by the tribunal in 2008 is actually much more well known than our final award. And the reason is because there were a lot of statements of law made in this particular decision, even though it was not an award, which has since been quoted many times in subsequent ICSID awards. Now, the particular activity that led to this decision was that it was discovered that the Turkish public prosecutor had been intercepting emails between the claimant and their representatives and their lawyers in the USA for the exit case. And there were, I think, hundreds, if not thousands, of documents which had been accessed by the Turkish government through the public prosecutor's office. Now, I'll just skip over to the next slide, but the next point is not terribly important. What is relevant here is that the tribunal asked Turkey, why are you intercepting emails and other communications between the claimants in this arbitration and their lawyers? And so this was the response of Turkey. There was surveillance of these emails and communications between the claimants and their lawyers, but it was not for the purposes of preparing for this arbitration, because the public prosecutors was an independent office charged with investigation of crime. And what Turkey said was that the claimants in this case were under suspicion of having committed several instances of commercial crime. And Turkey is a sovereign state. Surely we must be entitled to investigate crime, particularly serious crime, within our jurisdiction, even though there's an ongoing exit arbitration. And the email addresses, because we were furnished the list of all the email addresses of the person whose accounts had been hacked. These persons were thought of as conduits for communications with particular suspects, but it didn't necessarily mean that they were actually reading emails between the claimants and their lawyers about the arbitration. So they said, well, until you can show that, you haven't proved actual prejudice, so this thing shouldn't be taken much further. Can I have the next slide, please? Now, after a lot of back and forth, we came to the conclusion that there were certain basic rights that parties who were arbitrating in an exit arbitration or even any other arbitration were entitled to. And one of them was, and we didn't use the term guerrilla tactics, but we used the rights to arbitrate in good faith. So this, I don't know whether we can say that this was the first time that this duty had been mentioned in an exit judgment. And if you look at point 2 here, you can see that parties have an obligation to arbitrate fairly and in good faith. And an arbitral tribunal has the inherent jurisdiction to ensure that this obligation is complied with. And this principle applies in all arbitrations, including investment arbitration, and to all parties, including states, even in the exercise of their sovereign powers. So it's a strong statement that this is a basic feature of arbitration. I don't think, unfortunately, I think this decision wasn't furnished to the court in the Jaguar case, but so be it. And basically, our tribunal decided at the end of the day that we issued a series of interlocutory orders which protected the Libananco, the claimant counsel, from further surveillance, because there was also allegations that when the counsel came to Turkey, they were being followed around and pictures were being taken of them and the people that they were visiting. So there was a series of orders that were laid down by the tribunal to protect essentially the rights of Libananco as a litigant in this arbitration, so that the arbitration could proceed in accordance with generally accepted principles, whether you call it a duty to arbitrate in good faith or by some other justification. Next slide, please. That looks like the last slide. So you see how that balancing exercise was carried out. What the slide didn't show was that we also included a caveat on the series of orders that were given to the Turkish government. We extracted assurances from them that the two departments, namely the ministry that was dealing with the arbitration, which I think was the Ministry of Energy, and the Public Prosecutor's Office were to be separated. And while the Turkey as a sovereign state was entitled to investigate criminal activities, that investigation had to be separate, and there could not be any sharing of documents, particularly from the Public Prosecutor's Office to the ministry in charge of running the defense in the exit case. So there was this balancing act that was necessary. So there again, there was, this problem is not unique to this particular case. Whenever you have a foreign investor which sets up an office or a company in the host country, and they institute a treaty arbitration against the host state, some of the host countries will then start investigating the investor, because very often the defense raised by the host state is that the investor has been engaged in illegal conduct. So they say that, you know, you must allow us to investigate criminal activities, but sometimes it becomes very extreme because the exercise of those rights prevents the claimant, investor, from actually preparing its case. That's a separate, how shall I put it, a separate right. Typically, for example, you might get a host country sending in a whole team of investigators and seizing the documents of the local office of the investor. And then the investor says, well, I can't prepare my case. I will be precluded from presenting my case in full, and that would be a ground for challenging the award in due course. So tribunals have to find some balance to enable this kind of thing to be, to allow sovereign states the obvious right to investigate crime, and on the other hand, to ensure that the arbitration is allowed to proceed with full rights to the claimant to prepare its case, particularly with access to witnesses and access to documents. So I think at this point, by the way, I'll just say one more thing. This award, or this decision, as I said, is quite widely quoted in the books. And some of the language used is pretty stirring. And I can say this without undue modesty, because I didn't draft the really best parts of this award. But I had two very experienced co-arbitrators who between them, I think, worked out, they knew the limits to which they could carry the argument. And I think reading it now, I'm still pretty impressed with the kind of statements that we made at the time we did, which is quite a long time ago. But I think at this point, it'd be good for me to stop, and then hopefully I will join in the discussion after this. Thank you.
Thank you. Thank you very much, Dr. Hwang, and thanks for sharing with us your personal experiences and giving us a very good perspective on guerrilla tactics, not only in commercial arbitration, but also in investor-state arbitration. Our next speaker will be Victor Leginsky, and he will be talking about, among others, dilatory tactics in civil law arbitration, with Middle Eastern arbitration as an example. So, Victor, the floor is yours.
Yes, thank you very much, Janice. It's a pleasure to be here. As Vanina says, some of us are still in the morning, most of us are in the afternoon now, but greetings, wherever you may be. If I could have my slides put up, please. Yeah, we can move, I think, on to the next slide. That's just the beginning. So yes, I start with the bottom line here, which is that despite our best efforts amongst most of us, or a lot of us, delay is still happening. And as the slide says, and as was said by Janice earlier, this Queen Mary survey has changed in terms of its answer as to what's the cause of delay in arbitration between 2010 and 2018. In 2018, or sorry, in 2010, the survey subject says delays were mostly due to the parties. That is, the parties could control the delays. However, by 2018, it was seen, by the users at least, that the fault is mostly due to arbitrators. And that fault is because of due process paranoia. And that's a sum up of what has been discussed by Michael and Vanina, as arbitrators are afraid to breach the two manifest duties. Those are to allow a reasonable opportunity to present their case to the parties, and secondly, to treat each party equally. So if you've given a break to one party, then the other party will complain if they don't get equal treatment. And as has been pointed out, and Michael mentioned an award that ran to some 600 pages, and made many, many decisions along the way. In any arbitration, and I've done over 100 arbitrations as arbitrator. In any arbitration, you're going to have many, many decisions that you have to make along the way. And parties are going to be watching, like proverbial hawks, to make sure that they are treated equally, and they will jump on anything if they feel that their case is not going well, especially. They will jump on anything that seems to be a lack of an opportunity to present their case. So this allows or creates a fear in arbitrators that they're going to have their award set aside, because, as you know, the biggest duty for an arbitrator is to try their best and use every technique they have to create an enforceable award. So they have a fear that the award will be set aside, or that it won't be enforceable. Now, what this does is it turns one of arbitration's greatest strengths into a weakness, because, as we know, some of the biggest strengths of arbitration are that the parties have party autonomy, and they can choose the procedures that they collectively want. And they can do that in their arbitration agreement or during the course of the arbitration. So what that means is that international arbitration can be much more flexible. But with that flexibility is given discretion to the arbitrators. So the arbitrators have greater discretion, and along with discretion comes choices made by the arbitrators. And some of those choices can be jumped on by the parties to say, you exercised your discretion against my favor, or you gave the other party more discretion on adjournments, or time limit extensions, or those sorts of things. So this can turn one of arbitration's greatest strengths into a potential weakness, because there's not a black letter code of procedure for arbitration that's 800 pages long, as you have in rules of courts. In courts, you often have court rules, or you have civil codes of procedure in civil law jurisdictions, which parties in court have to stick to. Here, there is more discretion, so arbitrators then have to exercise that discretion in their best, under their best judgment. So let's go on to the next slide, please. Yes, so I'm based in Dubai, as has been said, and I've done over 100 cases as arbitrator, many of these having been in the Middle East. So the Middle East is a good example of two things that I think are important for us to deal with and focus on, and these are transferable to other contexts. As Benina said, Benina did a good job of talking about the Thailand context and what happens in Thailand. And the Middle East has its own cultural and legal context as well. First of all, the Middle East's legal system is, as the slide says, a civil law system. It's based on good faith. The claimant bears the burden of proving its case. There's an absence of discovery and limited requests for documents. The fourth issue, there's primary reliance on documents and secondary reliance on witnesses, and there is a reluctance to deal with witnesses. There's skepticism as to whether witnesses are even useful, because there is a tendency to think that witnesses will not tell the truth and will just simply say what they need to say in order to win the case for their respective party. And lastly, it's based on a system that the arbitrator or the court should know the law and should be able to apply it, so long as the arbitral tribunal does not exceed the party's claims or decide on matters that were not claimed. So that's the legal context. Now, culturally, in the Middle East, as elsewhere, there's a great respect for authority, but there is also a respect more for rule-based proceedings. So there is more of a sense of trying to turn an arbitration into a mini court case. And oftentimes in arbitration in the Middle East, they will cite from the Civil Procedure Code or other codes to try and sway the arbitration into more of a rule-based type proceeding. And this is also something that can be leapt on or used in court cases to try and say, no, the arbitrator departed from good proceeding because the arbitrator should have been more rule-based, should have looked at the procedural code, and thereby did not give me an opportunity to present my case or was not treating me fairly. In the Middle East, as elsewhere, I'm sure, there has also been in the past an unfamiliarity with arbitration. People are more familiar with court cases, and so they try again to present the arbitration more as a court case and don't take advantage of the flexibility of arbitration. There's also an unfamiliarity with cross-examination and with document disclosure that common law lawyers and common law systems are familiar with. Now, luckily in international arbitration, we have a blending of the two, the common law and civil law, using the IBA rules on the taking of evidence and soft law information like that to allow for a blending of the two. But still, there is a reluctance and a reluctance to have document disclosure, and they try and there is a tendency to fall back on old ways in this region. There's also an exuberance, you might say, in drafting and pleading. Oftentimes we get pleadings which are exhortative and full of underlinings and exclamation marks. This is obviously changing now with more and more information and understanding of sort of blended common law, civil law pleading styles and an understanding more of how arbitration runs, and also of good pleading and good advocacy practice, which tends to say cut down your pleading to the bare minimum and make sure that your pleadings are clear and not overly, not too overdone. And I was really interested in Michael's discussion of good faith, because this is something that is really active in the Middle East as well, as he will know from his many years in working there. Good faith is certainly a substantive right, or it's set out in the law in civil codes. What we're talking about here is procedural duty of good faith, I suppose. And I think that's something that could take root in the Middle East, because there is a real understanding of good faith and a real dependency on good faith. So that is an interesting discussion that one could have in the Middle East and elsewhere. Okay, if we can move on to the next slide, please. Thank you. Now, I'd like to run through some of the types of dilatory or guerrilla tactics that is discussed in the literature in relation to the Middle East, and also has resonance elsewhere. Bribery is obviously the first one. Now, luckily, all the laws in the Middle East have laws against bribery, and so there are mechanisms to deal with bribery here. One, I wouldn't even call it bribery, but there's one smaller version of this, which is the friendly co-arbitrator, which sometimes pops up in Middle Eastern arbitrations, where co-arbitrators especially are sort of in the pocket of the party that appointed them and doesn't act independently and impartially as they should. Now, this does pop up from time to time, and so you get co-arbitrators especially who are perhaps still discussing the case with their party during the running of the case, which is of course prohibited, but does happen. And I'm sure it happens elsewhere as well. Now, these are things that we're trying to limit and stomp out and get rid of, but these things still occur, and we try to eliminate them. And as you know, if a co-arbitrator isn't independent and impartial, obviously they'll have less sway with the chair anyway. So that often is a self-defeating tactic. Another item which was discussed by other arbitrators is intimidation and harassment of arbitrators and witnesses. Now, I haven't had any personal experience of witnesses being intimidated to the extent of being arrested or being kidnapped or any of that sort of thing. But what we do have in the Middle East is a culture of trying to sue the arbitrator. There's been quite a few cases of that where arbitrators get sued in a hope of getting them to resign, that sort of thing. Now, luckily, we have Article 7, the UAE allowed for someone to actually take a criminal case against an arbitrator. Now, that has been changed, so that is good. But there still are, as Vanina talked about, a lot of challenges against arbitrators, which may be frivolous, and again, lawsuits against arbitrators. So these are all aspects of techniques that are being done. The next one, derailing the proceedings by seeking certain orders. We used to have in the Middle East, a lot of cases of allegations of forgery, because as you know, civil law proceedings are very document-based. And so what often would happen is parties would go to court and say, this document or that document are forged, especially if the document was against their interest. Or if they wanted to derail a proceeding, they would say the entire contract is forged. The signature was forged, or we didn't sign it, or we need to see the original, all those sorts of things. Now, luckily, most of the Middle Eastern states have adopted new laws which make it more difficult to derail proceedings because of that. For example, in UAE, we have a new arbitration law in 2018. Prior to that, the Civil Procedure Code, which dealt with arbitration, said if there is a bare allegation of forgery, then you have to suspend the arbitration, you cannot proceed. So that was quite an easy out for someone to try and derail the proceeding. So luckily, these are getting less and less. Hacking, wiretapping, other surveillance, that's again something that we have to watch very seriously everywhere. I had a case recently where not so much wiretapping or hacking, but there was, as I think Michael was discussing, or Vanina, I don't recall which, an over disclosure. There was a dumping of documents in this case, And in some of the documents, the other party found links to yet further documents which weren't disclosed. And so they used those links to access other documents and other websites, which then led them to other information that the first party said they shouldn't have done. So I was a sole arbitrator in that case, and I had to deal with that as an application. And luckily, the majority of the documents that were found using this method were also part of the document dump. So there was no real harm done, and I rendered an order that stopped the party from doing this in the future, so that that couldn't happen again. So there are various ways using electronic techniques of obtaining information. Fraud is another frequent allegation, but obviously we look at this very seriously, and there has to be a high level of proof to show fraud. So that is, one can deal with that. Refusal to proceed with the arbitration proceedings, well, that's resorted to quite often. There are, a lot of rules that allow you to proceed in the face of non-participation. So that is something that can be dealt with. Next slide, please. Again, repeated challenges against arbitrators, we've dealt with that. And that is a common practice. And as was said, sometimes that leads to arbitrators resigning because they don't want the trouble of carrying on. We also have in the Middle East some parties who make allegations against specific arbitrators to try and get them to engage in rebutting those allegations, and thereby becoming biased. That is, by making counter allegations against the party that made the frivolous allegations against the arbitrator. That's another technique that's used by some parties in the Middle East. Delay of submissions, last minute postponements, all of these are used by parties, ignoring orders, etc. These I will deal with when I look at the solutions to these kind of dilatory tactics. Next slide, please. Which is a segue into the solutions section. And there are some definite solutions which can be used in any part of the world and in any context. The first is observing and referencing the applicable ethical code of conduct in the first procedural order. So the first thing is to ensure, and a reference has been made to the LCIA rules, for example, which imports some ethical matters into an arbitration, but one has to have in there, sometimes you have special rules that you put in an arbitration. We do that in our ICC cases quite often. We have specific procedural rules that we get the parties to agree to, and we do have ethical and procedural safeguards built in there. So the first thing is to set up your arbitration for success rather than failure, and put in as many guidelines as you can at the very beginning. In the beginning of an arbitration, you may have a honeymoon phase where the parties are less reluctant to counter the arbitrator. In some cases, the parties are fighting hammer and tong right from the beginning, so you don't have the honeymoon phase, but you're more likely to get good procedural rules in the first instance than you are later on. Next is providing a strict and detailed procedural timetable. Now that's important in any case, but most important in cases where they're large, complex, and where the parties are really fighting very, very hard. And that's most cases now, because arbitration has become more and more adversarial as the years have gone on. I've been doing this as an independent neutral for about a dozen years, and I think cases are getting more and more tightly and hard fought, I think, as the years go on. Now, in number 2, it says providing a timetable. Now, what we'll talk about later on is sticking to that timetable. I mean, the most important thing for an arbitration tribunal is to stick to the timetable, and that means reminding parties of an upcoming deadline before the deadline comes up, maybe two to 3 weeks away, and then reminding them again. And then that way you signal to them that you're going to stick to that timetable. Number 3 is making disambiguous the counsel obligations and agreeing a workable style of advocacy. So what you have to do is make sure that you have advocacy that works in your context. As I say, it's a blended civil law, common law style. You have to make sure that what you're doing is not forcing civil law counsel to become common law lawyers, because that's not going to work. So you have to make sure that you have a system that works in your context. Detailing the appearance of witnesses and experts, that is quite important, because you have to make sure early on that you get the parties to say who their witnesses are going to be, how they're going to appear. And in current context, we have mostly appearance by video or by electronic means, and you have to make sure you set up a good system for doing that. And then make sure early on whether there's going to be a problem getting the witness to appear, because obviously having a witness not appear is a good delaying tactic if a party wants to play that card. Outlining the principles governing production and admissibility of evidence. Now, that's very, very important, especially in a civil law context, because, as has been said, there is a reluctance for discovery and disclosure. You have to have a lot of rules around that you outline at the very beginning. For example, when you have a document dump of more documents that were called for, you first of all want the other party to complain about that so that you can limit the document as an arbitrator. You also want to make sure that you make it clear to the parties that any document disclosed can be used in the arbitration, because I've had that as a complaint where there has been a document dump, and then the dumper says, you can't use my documents. The other party has to have signaled that that document needs to be used before the arbitrator can say that that document can be used. Well, that's not, I mean, that either is or isn't the case, depending on how you have set up the disclosure from the beginning. So you have to think ahead as to how the disclosure will be done, and then how the documents can be used in the arbitration. Next slide, please. Then you set out the principles of good faith. I think that's been discussed by Michael quite clearly. And the arbitration tribunal, you have to have some form of civility and ethics set out, something to refer to. There are guidelines set out by the IBA, for example, in party representation. There are the books and provisions that Michael's referred to. So there are things you can look at in that regard. The next one is seeking interim relief from arbitration tribunals or national courts to preserve evidence or thwart devious tactics. This, I think, is important. I think arbitrators have to be more proactive, especially in the face of any kind of tactics, to make sure and nip them in the bud, as we say. Number 8, seeking orders reprimanding counsel and notifying bar associations of counsel misconduct. This is a little more difficult. I mean, this is more for, I think, parties to do. It's difficult for our tribunal members to get into this fray, but certainly that's something that parties can look at. And again, a party one, number 9, seeking damages and cost awards, sanctioning misconduct by the party and its counsel. Obviously, at the arbitrator level, where I sit, we have to be sensitive to this, and we have to make sure that we are willing to take both cost awards as well as make adverse inferences, because that's the two techniques we have in countering these sorts of things. We have cost awards and adverse inferences in dealing with these types of behaviors. Now, I've cited in my presentation a paper by Professor Klaus-Peter Berger and Ole Jensen in some of these things. And they sum up the solutions in 4 items: transparency, proactivity, interactivity, and proportionality. So what they say, could I have the next slide, please? So what they say is that you have to be transparent, which by that we mean as an arbitration tribunal, you will signal to the parties that you're going to stick to time limits, that you're not going to put up with any negative behaviors, that you're going to hold counsel to an ethical standard. I had one case, for example, I was chair of an ad hoc arbitration seated in the Middle East, and the parties were fighting quite hard, and one party had a Western style counsel, the others had an Arabic style counsel, and the Western counsel said that some of the tactics employed by the Arab counsel were shameful, and using words like that, and that caused the Middle Eastern counsel to walk out, because that word had a loaded and a much more negative connotation in the Arab culture than it did in the Western culture. So as a tribunal, you have to be aware that these cultural things can pop up. We had to deal with that, and we had to ensure that the Western counsel apologized for the use of that word and explained what they were trying to do, and we managed to get the other counsel back into the hearing at that stage. But you can see how you have to be prepared to deal with these types of matters, and you have to be transparent that you're going to deal with these matters. You have to be proactive and interactive, two items that Berger and Jensen talk about. Proactive means you have to act quickly and early. Interactive means you have to understand early what the parties' submissions are, what the requests are, what relief they're seeking, and then have frequent, especially in large cases, frequent case management conferences to sort out what the parties are seeking and to tease out any lack of particularization or any inconsistencies in the requests. Because sometimes if you leave it to the hearing or after the hearing, you may get inconsistent requests for relief, or you may have new requests for relief that sneak in that you haven't dealt with. So you have to be on top of the pleadings and submissions at all times, and make sure you tease out any inconsistencies that may give you trouble in drafting the award later. Proportionality is the last one that they talk about, and that means you do have to vary these techniques depending on the size and complexity of the case. This slide basically says that tribunals have fundamental discretionary powers to ensure the integrity and the efficiency of the arbitral proceedings, and reveals that due process paranoia is unjustified. So both authors, Wilhelm's daughter and Klaus-Peter and Jensen, say that we shouldn't be so worried about what courts are going to do. In fact, Berger and Jensen summarize it into what they call a procedural judgment rule. That is, a court will not second guess an arbitrator's exercise of his procedural judgment if his or her decision is grounded in a bona fide assessment of the case and is reasonable in the circumstances. So courts are reluctant to interfere with arbitral proceedings generally. Now, I have to say that Klaus-Peter and Mr. Jensen did use English and American courts largely for their discussion. Middle Eastern courts may be more subject to outlier type cases where they may allow an allegation of due process, that is, I wasn't given a reasonable opportunity to present my case, I wasn't treated fairly, to set aside an award. So that means arbitrators in some jurisdictions just simply have to be more careful. Next slide, please. Again, authors say that due process paranoia is unnecessary. Now, there is an argument, there has been an argument made under the model law, which uses the phrase full opportunity to present your case, but cases have interpreted even the full opportunity to mean a reasonable opportunity. And most rules say reasonable opportunity, and that allows arbitrators a fair latitude in making their discretionary decisions. So what the cases say is the right to be heard is not absolute and does not cover unreasonable, dilatory procedural requests. So if you, as if an arbitration tribunal has been transparent and has signaled early on that it's not going to give unreasonable requests for delays or extensions, or allow in unbidden submissions, because often we say, you know, you will have, we set out the procedure of making submissions on a certain point, and oftentimes parties try and sneak in another submission that wasn't allowed for in the procedural order. The tribunal has to be clear and just say, we're not going to consider any unbidden submissions. Another indication of that due process paranoia is not necessary is because parties' due process rights do not require arbitrators to abandon all efficiency and are not ends in themselves. I mean, as you know, this arbitration system is something that you try to ensure efficiency, because that's what parties take arbitration for. It's an efficient way of resolving their disputes. And so this cannot negate that benefit of arbitration. As they say, they cannot result in rendering arbitral discretion nothing more than an empty shell. It has to be discretion, and discretion means you have to make decisions against parties sometimes in the right context and in the right situation. Next slide, please. So that's the end of my slides. I did see a few questions come in. There was a question as to whether domestic arbitration is fraught with the same dilatory tactics, and will it be decided in the same way? I should say, especially in the Middle East, many of our cases are classed as domestic arbitrations, because even though they're international parties, oftentimes they set up local companies because that's what the law requires. And so they are seen to be domestic arbitrations, but they really are international arbitrations in that the parties are international players. And so we see the same tactics. We get very large domestic, in quotes, cases. We see the same tactics there, and we have to handle them in the very same way. There was a question about arbitration institutions. Can they be held accountable? What often happens in, as you know, in arbitrations is that parties will challenge arbitrators at the time of their appointment or when they're pending confirmation by an arbitral institution. And the institutions have a tendency, everywhere I think, just to not appoint those arbitrators if there's any hint of controversy. And so you lose a lot of good arbitrators out of cases because parties simply want to continue to question them. And there's nothing you can do about that because, of course, institutions are very reluctant to put an arbitrator in a case where there might be controversy. So that's simply that. But having said all of that, I thank you again for listening to my brief presentation, and I'll be pleased to answer any further questions that come along. Janice?
Thanks very much, Victor. And for our final speaker, definitely not the least, we have Professor Steve Ngo. And again, for all the persons who have any questions, please feel free to write them in. Steve, you have the floor.
Yes, thank you, Janice. And I'm conscious that we are running out of time, so I will try to be as brief as possible. I will speak quite quickly. If you have any issue catching what I'm saying, so please ask any questions, or you can even email me after this. I'm also conscious of the fact that all the participants should be given a fair opportunity of presenting the questions, isn't it? This is a webinar. Right, first of all, good morning, good afternoon, and good evening, depending on where you are. First of all, thank you very much to the Thailand Arbitration Center for having me here today. Today's webinar topic sounds like a long essay examination question, to be honest, and I wondered who so cleverly came up with this topic. But nevertheless, I have certainly put in some efforts in preparing for my presentation, and I must commend TAC for organizing such thought-provoking series of seminars. There is much to talk about this topic with very limited time, and also my other fellow speakers with distinguished backgrounds have addressed this topic extensively before me. In my presentation, I would like to invite you all to suspend judgment for a short moment and consider the smorgasbord of arguments depending on which side you are on, as there are always two sides to every story. At the outset, to answer the key theme and exam question here, is there an impact from dilatory tactics on the efficiency of international arbitration? The plain answer is in the positive, but substantively, it is also a matter of perspective of either one is the claimant or the respondent. Naturally, claimants want to win the arbitration quickly, whereas the respondents want to end it quickly without losing. Otherwise, they will have all the time in the world to play it slowly with the claimants. For this reason, it wouldn't be surprising if the enterprise of respondents in arbitration tends to be a low investment one and likely to be cash-strapped, unless, of course, there are counterclaims. When claimants strategize how to attack his opponents with a win, the respondents similarly think of how to extinguish the claim. Time can become the biggest enemy for both parties. Too slow is too bad for the claimant. Too fast means the end comes swiftly for the respondent. Empirically, the successful respondent counsel in arbitration are a clever strategist who needs to be thick-skinned, quarrelsome, brave, and determined. Not necessarily in that order, but somewhere there. Sometimes they have motivations too. Take, for instance, in common law jurisdictions, lawyers typically cannot accept contingency fee arrangements or CFAs. But in civil law jurisdictions, such as in China, from my experience, counsels respondents can receive fees on CFA based on the percentage of the savings made from successfully defeating the claim in part, or better still in full. Hence, there are motivations for the respondent counsels to work very hard. However, at the end of the day, respondents need to be represented, and arbitration counsels don't always get to act for claimants only. On one hand, putting up a fight is not like musketry, volley fire, where ancient soldiers line up taking turns firing at each other. Respondent counsels are engaged to come up with all sorts of strategies and tactics, sometimes extremely annoying and distressing. The key question is, of course, the extent of the conduct, whether ethical and potentially illegal. I will now briefly deal with the good, the bad, and the ugly of it all. I'll start with the good, where somewhat I will enter the realm of darkness in arguing for the merits of dilatory and guerrilla tactics. The fact is, respondents are not always entirely the villains, and they seldom believe that they are the perpetrators, but rather they are the victims. At times, unfortunately, all negotiation attempts fail without a willingness to compromise, thus leading to arbitrations. There is a local Indonesian saying that there are two things in life that must be avoided: getting ill and getting a lawsuit. Learned Hand, one of the American leading jurists, said that he fears lawsuits more than death and taxes. For this reason, mediation is taking center stage these days as early intervention to resolve disputes without going into full-blown litigation or arbitration. Perhaps some claimants have not given their claims a serious thought, or they could be up against a strong respondent who will fight back with all available means. But in addition to non-commercial arbitrations, I would like to say a thing or two about claims against third parties from my previous experience. In developing countries where its government becomes the subject of a claim against it in arbitration, funds are always a major challenge because, unsurprisingly, there are no state budget allocations for arbitration and hiring of external counsels, which of course they will never anticipate that. They may need to seek emergency funding, which will take time to be disbursed by the Treasury. Meanwhile, an agency or relevant state organ will temporarily fund the arbitral proceedings, and the game is always to try to delay it whenever they can. Now, these days, with access to third-party funding, claimants tend to be less conciliatory about resolving the dispute. I am not judging the intentions of the parties going to arbitration, but it is reasonable to say that not all claims are perfect. However, third-party funders, in essence, are investors, and they don't welcome surprises. It is implicit that when respondents find out that TPFs are involved, or third-party funders, they will raise the ante with dilatory or guerrilla tactics to add pressure to the claim. This may bring the arbitration to a quick death at times. Challenging the arbitrator is another form of attack, for the tribunal is key in the arbitration. Attacks like challenging the independence or impartiality of arbitrators, ranging from taking pot shots like articles previously authored, blog posts, LinkedIn posts, Facebook posts, you name it, sometimes may succeed, casting doubts and leaving the tribunal very shaken, or revealing certain compelling circumstances which otherwise might be left undisturbed. while dilatory tactic is about delaying to frustrate the claimant on the premise that time is precious to the claimants, sometimes claimants also know that they need to bide their time. Quoting Sun Tzu out of War, one of my favorite quotes. It says, whilst no battle is won by haste, neither is war by delay. So hence be very careful what one asks for in terms of disclosure or document production, because what the respondent asks, the claimant can similarly request the same from the opponent, since what is source for the goose is also source for the gander. And who knows, the dilatory tactic might end up be favorable towards the claimant. I now turn to the bad. Now, to a certain extent, perhaps because of due process paranoia, also depending on the experience and background of the arbitrators, tribunals tend to take a hands-off approach, at least in the beginning, if the attacks especially have not yet be directed at the tribunal. So it is often said that the tribunal, the strategy is to fence themselves first, in the first instance. Well, there have been criticisms that arbitrators are fearful of getting into the bad books of the parties and potentially getting blackballed for future appointments. They might be concerned about intervening too soon and too harshly for fear of the consequences of having their awards challenged later. However, such criticisms are not always justifiable, since the tribunal do assume that the claimants should fend for themselves and not be defended by the tribunal. The claimants can object to such dilatory tactics and the tribunal's interventions, but this will also be dependent on their procedural rules. For instance, if we look at the ICC rules at Article 22, paragraph 1, the tribunal shall make every effort to conduct the arbitration expeditiously. Yet at paragraph 2, the tribunal consults the parties and may adopt appropriate procedural measures. Then at paragraph 4, the tribunal is reminded to act fairly and ensure each party has a reasonable opportunity to present its case. And finally, at paragraph 5, the parties are required to comply with any order made by the tribunal. Now, from my observations, the tribunals tend to let the parties do their work to a certain extent until such time when the party started attacking the tribunal. When the guerrilla party makes too many applications and delays severely, affecting the claimants, and at the urging of the claimant, the tribunal will also need to do something about it. Delays can also affect the tribunal, and at times also in terms of the remuneration, because typically arbitrators only get paid by arbitral institutions after the conclusion of the proceedings. So from my experience, what are some of the common dilatory tactics? They include, number one, challenging the validity of the arbitration, arguing that it is premature. This is very common for respondent to raise an argument that the arbitration is not valid because the claimant is yet to exhaust all avenues available to negotiate or mediate as per the arbitration clause, in the case of a met-up clause. Two, other delaying tactics which can be downright irritating, public holidays, being busy and illnesses and so forth. And of course, thirdly, I mentioned earlier on, attacks on tribunal, which usually will be unsuccessful, but can distract the tribunal. By the way, attacks on tribunals are very real, and as a cautionary tale, I would suggest anyone who to read out the Singapore case of Koh Brothers Building and Scott's Development. In short, the arbitrator came under intense attack by a party because of an application for an interim award was refused. In fact, Justice Prakash in the judgment observed that the conduct of the solicitors to be deeply disturbing, and they should not have harangued the arbitrator or sought to influence his decision by brandishing accused C's opinion in his face. Their conduct leaves a strong impression of bullying. Again, this can happen in arbitration when the party is seeking to derail the proceedings that put intense pressure, especially on the less experienced arbitrator. In the interest of time, I will cut to the chase here to talk about the ugly side of things. Those among us who have been involved in arbitration for a while here in this region would have heard of this infamous case of the kidnapped arbitrator in the late 1990s. It is a classic example of guerrilla tactic, but it is historical. People no longer do that, I believe. In good faith, I believe people don't do that anymore. Hence, I don't plan to be too explicit about the case, and I'll leave it to you to find out. However, I'm happy to share with you some of the juicy bit of it. It is actually a BIT arbitration involving a state party, and as reported by Neely's International Arbitration Report, here is a litany of tactics deployed by the respondent party. 1, refuse to accept service or statement of the case. 2, attempt to enjoin the arbitration with the local court proceedings. This is not unheard of. In commencing parallel proceedings, in particular, I have seen when the court decision varies from the tribunal's order, the party may then invoke grounds of sovereignty. 3, the threat to prosecute and imprison the claimant's counsel in this case. 4, issuance of an injunction by the local court against arbitral proceedings. 5, challenge of independence of the chairman of the tribunal. And finally, kidnapping the state-appointed arbitrator. And they hope that by this will thwart the hearing and no award can be issued. However, the truncated tribunal of 2 went ahead to issue the award, citing authority from a former ICJ judge. Also, we have all our own horror stories to tell, especially in the light of digital technology, where emails are now used extensively in arbitration. In one particular case that I was involved, it involves quite a number of representatives and experts copied in the communication, and no one knew or paid attention to an unknown email which had been appearing for a while. Then one fine day, it was alleged that the mysterious person wrote to one of the party's representatives, and this was reported to everyone. No one knew the motive or identity of the mysterious person, but might there be repercussion towards the proceedings later on should this was not discovered is anyone's guess. I shall now close. I shall now close with some reflections that without being too quick to judge and be sanctimonious about things, I think some dilatory tactics have indeed drawn something good out of it, quote and unquote, good. One such example is how in the matter I was involved, for instance, and of course, all of you have your own experience and examples. The arbitrator's independence was questioned and a thorough explanation had to be eventually given. However, of course, there can be serious repercussions to the guerrilla parties where costs can be awarded against a party making frivolous requests or deploying other delay tactics. It will all be too obvious at some stage, where even if it is disguised as valid demands by the respondent and in the name of due process, because these willful acts can become very apparent, especially to very experienced arbitrators. I think Dr. Hwang mentioned that earlier on about in the Jaguar case about how deaf and able the tribunal was, so they sort of anticipated that. So this is a cautionary tale for those who are predisposed to dilatory tactics. Now, some guerrilla tactics are much more aggressive, but whilst it may not involve muscles, it certainly involve brains. Consequently, some concerns and issues need to be given further talks about how we could possibly eliminate them. Take, for instance, witness coaching, where licensed legal practitioners, say in common law jurisdictions, are largely prohibited from doing so. However, when arbitration can be self-represented, how do we deal with this issue? Then there will be also many among us who regularly take on roles as defending counsels, and some will argue that it is indeed a matter of perspective. But whether it is a dilatory tactic or purely tactical as a matter of doing it adroitly, I am not a sympathizer of dilatory or guerrilla tactics in arbitration, for they do unstitch asunder the fabric of arbitration. And indeed, why our disputants choose this method of dispute resolution is because they wanted arbitration. However, the clever counsels know their limits and often also doing it within the gray area of rules and regulations. Finally, in the hands of the experienced arbitrators, she will not be sucked into this vortex of paranoia or stepping into the traps laid by the guerrillas. Even so, can the strong arbitrator be bold, assertive, or skillful in spotting guerrillas in action and put a stop to it? Can he or she do it? Threats of breach of natural justice, removal of arbitrators, or even challenge of the awards can weigh down heavily on some arbitrators as they felt duty-bound to render effective awards. To the deft arbitrator, they are unlikely to tang in. They know that if they have gotten the fundamentals right, all threats that would be ineffectual in the end, as the saying goes, that dogs may bark, but the caravan passes. However, there might be a price to pay at the end of the day. Thank you so much for your attention.
Thank you, Professor Steve. So we've heard from all of our speakers today, and it's been very, very interesting. Especially for me, I think as counsel, I have experienced my fair share of guerrilla tactics from the opposing party. So it's been quite interesting understanding the point of view of tribunals and arbitrators in dealing with such guerrilla tactics. Now, in interest of time, I do know that there are several questions which have been submitted by our participants. Some of them have been answered live, and some of them have been answered in the Q&A box. So I would like now to go to some of the unanswered questions. Again, very interesting questions. First, I'd like to ask our panel today, so can you provide us with a comment on how arbitrators or tribunals should approach awarding costs as a sanction on difficult or uncooperative parties for party misconduct. And when you provide this approach, can you maybe provide also some examples that prompted you to issue these kinds of awards?
From my point of view, I think it's important to signal early on that you're going to be taking this approach. As I said before, you have to plan for success and not failure, and you have to make sure you have the power to shift costs based on performance or on ethical or delay or other types of activities and other types of actions. So you have to make sure that's built in either in the procedural rules somewhere. You can reference the ICC's procedures on time and costs. There are various ones you can reference, but make sure you've got that power initially. Otherwise, you're heading into dangerous territory if you try and shift costs based on dilatory tactics, and then you find that you didn't have the power to do it. So I think that's the first step. The second one is, and Michael talked about again, his 600-page award. Unfortunately, what you have to do then is you have to write up in the award very carefully and clearly what occurred, what dilatory tactics happened, how you dealt with it at the time, and then it should lead to a conclusion that allows you to shift costs against a party that engages in such tactics. So that's sort of two approaches, if you will.
Thank you, Victor. Perhaps any of our other panelists would have other views? All right, let me move on to another quite interesting question. And this one deals with the deposits in terms of an arbitration and the failure to pay them. So as we know, in most arbitrations, especially institutional ones, the deposits are actually shared equally by the parties. So the question deals with the instance or an example of when a respondent does not pay his share of the deposits. So the question goes, while it is possible to pay on behalf of the respondent and get an interim award for the cost deposit, the enforcement process is often disruptive and something that parties would prefer to avoid. It is also difficult to strike out the respondent's defense, unlike the case of a claimant refusing to pay its cost deposits. So how do tribunals ensure that such recalcitrant respondents do not commit such infractions and unnecessarily prolong or drag the time? So perhaps Dr. Hwang, if you could start off, and then it would be good to hear responses from the panel.
The short answer is that, as Andrew has highlighted, the only real remedy that can be invoked is to get an order from the tribunal to direct that any advance made by the paying party to make up for the shortfall from the non-paying party will be reimbursed immediately. That will involve a parallel application which should not hold up proceedings in the main arbitration. There used to be a doubt as to whether or not you could actually do it within the same arbitration, or you had to go and start a new arbitration to enforce basically a contractual right of the paying party to seek reimbursement, because in the arbitration agreement, both parties agree to abide by the rules, and the rules say that each party has to pay 50% of the advances requested by the institution. But most arbitration institutions now have put it into their rules that this kind of an application can certainly be made within the arbitration itself, and you don't have to run off and start a fresh arbitration. And secondly, that you can actually make this an award as opposed to a simple decision, because if it's an award, then if the party, non-paying party, is in a separate country, then you can go to that country and enforce it under the New York Convention. And that's the best you can do, I'm afraid. Now, where the defense is joined to a counterclaim, and you've got the ICC, then what you could also do is to ask the ICC to refix the shares so that the paying party, which is usually the claimant, doesn't have to pay the defendant's share of the counterclaim. So they refix the deposit so that the claimant is responsible for the advances only on the main claim, and if the deposits on the counterclaim are not paid, then the counterclaim will just lie there and not be progressed. I'm afraid that's the best that can be told, but theoretically it should not be that disruptive because it's a simple application. There's probably no defense to non-payment of your share of the deposits, and you'll be able to get an interim award fairly quickly, and then you enforce it however you can.
Yeah, two points on that, if I might. I know I've had in ICC cases, I've had those applications where the one party pays in substitution, the other party wants to have its cost awarded to it. You have to be careful that you're in a jurisdiction that will enforce interim awards or enforce partial awards. Some jurisdictions won't do it, especially in the Middle East, so you have to be careful you're not going to make a hollow order. The other part is Michael talked about counterclaims, and you do have a bit of a difference between, at least in my experience, a difference between ad valorem institutions and hourly paid institutions, because hourly paid institutions tend to make, to demand the parties pay a certain amount based on hours for the rest of the proceeding, and they don't make separate demands for the counterclaim. So then that puts the respondent in the position having to pay all of its claim, which it didn't pay for the claim, its portion for the claim, as well as for its counterclaim. And oftentimes the respondent won't do that. And then the tribunal is in the unenviable position of saying, well, we can't consider your counterclaim. So there is a bit of a difference, I think, in institutions with regard to counterclaims.
That's correct. And I think just for institutions as well, what Michael was saying earlier about refixing the proportions of the deposits is quite relevant, especially when the counterclaims, the amount of counterclaim and the amount of the claim there's a huge disparity between them. So if you have a non-paying respondent, it really helps for the claimant to request for this institution to refix the apportionment of the deposits. Professor Steve, perhaps I know that you're also handling your own as founding president of an arbitral institution. Do you have any thoughts on this?
I'll just speak generally, Janice. I think if we get into the psychology of respondents, if they do not have any counterclaim, then they felt that there is no need for them to contribute to the cost of the arbitration, the deposit. And even more so, they feel that if they were to do so, that would that'll be contrary to their views that they will maintain that the arbitration often than not is not a valid arbitration. So you always take this guerrilla position of saying that I'm not going to pay it, I don't recognize this arbitration, I will challenge this tribunal. By paying, I will be admitting to the validity of this tribunal, so I will not do so. And better still, as I've said earlier on, it is often a low-cost enterprise. The respondents do not want to contribute any money. Unfortunately, if there is no counterclaim on the part of the respondent, as we all know, many arbitral institutions requires the claimant to put up the share of the cost, failing which it may affect the continuity or the continuance of the arbitral proceedings.
Thank you for that. I'd like to go into a question about ethical regulations. So this is a question that has been answered actually by Michael in the Q&A box, but I wanted to check with Vanina for your point of view. So the question is really, I'm seeing that guerrilla tactics often involves ethical clashes or are ethical in nature. Do you think that is a uniform or universal ethical regulations binding on all players at the international level? Is it something that's practicable or possible even? I think you may need to unmute yourself.
Yes. I think that's something that would be quite difficult because we come from different legal backgrounds and cultures, and I will just give the example of ISDS at the moment, where there's consideration for a universal code of conduct for adjudicators. And even that is raising a lot of controversy. And we're talking about treaty arbitration, which is governed by international law or treaty law. But if we're dealing with different common law, civil law, different national laws, to come to a consensus on ethical guidelines would be quite difficult. As I gave examples earlier, that what is acceptable in one jurisdiction may not be acceptable in another jurisdiction. But there is the IBA guidelines on party representation. And this is something that could be brought up by the tribunal as to whether or not to adopt this in the procedural order, or which provisions to be adopted. And the tribunal may also consider, if it's not in the institutional rules, such as the ICC having the duty on the parties to act expeditiously, then whether or not to adopt certain standards and incorporate that into the procedural rules. And I think that's the beauty of the flexibility of arbitration. But realistically, to have universal guidelines that would be adopted by all institutions would be quite difficult.
Thank you. Thank you for that. We have generally answered the questions from the participants, and we're very thankful again for your time. And I am also mindful that it is now 5 p.m. in Bangkok time, which means we do need to conclude with this webinar, and it's been a very, very informative webinar. I'm sure not just for our participants, even for me personally. If you do have any other questions that you would like to add, feel free to reach out. You can also, perhaps ask the THAC. Should you wish to do so. And if there are no further concluding remarks from the panelists, on behalf of the panel, then I would like to thank everyone for their time and attention in being with us for these 2 hours of webinar on this particular topic. So thank you very much to everybody, and have a good afternoon, a good evening, or a good morning.
Thank you all very much. Thanks to the team for inviting me. Thank you.
Thank you.